My name's Owen Leslie. Welcome to today's webinar. We've still got people coming on, so we'll just do a bit of housekeeping as we get started, but happy Friday, everyone. So just got a few announcements to go through first as people start up. I just wanted to let everyone know just about this webinar. We've got the chat feature up in the top right-hand corner, I believe, that you can use to ask questions during the webinar today. So if any questions, you can just write them in. We are going to do a question and answer at the end of Clarence's and Neil's presentation as well. So, and we have a react button as well in the bottom left-hand side as well that you can utilize on this webinar format as well. So please feel free to use those functions, the chat function and the react function as well. All right, just moving along to the next slide. Just wanted to let you know about our NECA. If you haven't heard about NECA, it is our AI virtual bot that we built in-house. We spent many, many months building this, and it's very exciting. So what it is, it's a state-of-the-art AI industry expert built specifically for the electrotechnology industry. So we've got our member knowledge base, which is extremely full with a lot of resources and information. And what we've done is we've designed this AI bot to read all the information in our MKB, including standards, policies, procedures, safe work method statements, safe working procedures, toolbox talks, fact sheets, everything that we've got in MKB. NECA now sort of scrapes that information for answers, which you guys can utilize to answer your questions that come through very, very quickly. So it offers quick access to expert knowledge. So if you need an answer quickly, you can use NECA. It doesn't replace, obviously, all our experts, because our experts keep feeding it and do have to provide the last answer on it and make sure that it is giving the correct answers. But yeah, it's a very exciting little product, and at the moment I believe it's free for trial for all NECA members as well. So and I am going to announce a little bit later on, we've got another webinar later on this month in regards to NECA as well. So if you haven't checked it out, give it a quick go. It's a very, very exciting development that we've been working on for several months now at NECA. All right, we'll go to the next slide. Talking about the member knowledge base as well. So we've got that new NECA AI search functionality built in, which access hundreds of documents. Once again, if you haven't used MKB, we've got Australian wire rules, access to 46 Australian standards, free for you guys, so you don't have to go and pay anyone for those access to those standards. Technical support for in-depth industry insights. We've got the NECA Safe Light Safety Management System there with all your basic DIY pre-written templates for you to build your own system. Legal and workplace relations, including contract templates, wage guides, and over 100 downloadable employee management tools, and business support tools, including the charge out rate calculator, disaster recovery guides, and there's so much more. It's so full, this member knowledge base. It's definitely the biggest knowledge base in our industry. So if you haven't checked it out, it's a good time to check it out. All right, moving on. Just to let you guys know as well, we have 4 safety management systems as well: NECA Safe Light, NECA Safe Digital, NECA Safe Generator, and NECA Safe Empower. We are talking about work health and safety reforms today and the impact on your businesses. These systems help you guys keep compliant. They are industry specific. They do provide liability protection. They offer a bespoke solution to your challenges that you have in that compliance space. They're supported by real professionals. We have NECA Safe advisors employed by NECA all around the country. There's actually 8 of us in the team now, so it's really well supported team. It includes pre-written templates and software as well. and it has lots of variable cost points as well to suit your budget or challenges or everything like that as well. So look, if you're looking to improve your safety management system, or just have a look around to see what's there, or you don't have anything in place at the moment and really need to get onto it, you know, give us a call. We're going to be able to jump on and help you guys out as well. Yeah, good option to come there. We normally start with an annual safety review to see where you guys are at and provide a gap analysis and solutions on how to fix those issues. Another thing that we got at NECA Safe is the NECA risk-focused toolbox talks. So my team has been developing, each one of my safety advisors is developing a toolbox talk per month, and these things are beyond useful now, the format that we've got these in. So we settle on a theme every month, and we've got a 2-year cycle of themes. So in August, we covered machinery, plant and equipment. Then in September, electrical hazards. October, confined and restricted spaces. And this month, radiation extreme temperature hazards. And what you'll see is we call it a solar CDM, which means it's an email that gets sent out to the membership. They'll get access to an email, and on there will be access to the 4 to 5 toolbox talks that we've developed for that particular month. So we just sent one out, I think it was almost just a week and a half ago now, that covered radiation extreme temperature. And in that, you would have had access to extreme heat and dehydration toolbox talk, the UV radiation exposure, radio frequency radiation toolbox talk, extreme weather, and flood affected sites in that little package for that month as well. But if you go to MKB, you can go back and collect the toolbox talks from confined and restricted spaces, electrical hazards, and machinery, plant, and equipment. And in February next year, we're going to start on the HSEQ management toolbox talk side, and we're going to be covering legal and policy management. And after that, we're going to cover risk management and move through the year like that. The idea of this is that if you're doing toolbox talks from each month, you're basically going to be covering every single hazard in your business over that 2-year period. And it works well in an ISO compliant safety management system, because you basically spread your audits out over the whole 2-year cycle. They're more than just toolbox talks too. There's a inbuilt quiz, which is online, which develops a certificate as soon as one of your workers completes it, and that certificate can be kept on record for verification of competency. It's also got a self-audit tool in there as well, which again, helping for that ISO compliance. Split up into 2 sections of toolbox talk: an easy to read information section, which just gives you the highlights of maintaining safety. It's quick, short, sharp, and concise. And then there's an additional resources section, which has a lot more details if you have more complex questions around that issue as well. But not necessarily for communication, more for research and training purposes as well. So excellent little resource, these risk-focused toolbox talks, so check them out. Just while we're waiting for a few more people to come on, I want to let you guys know about our NECA site inspections as well. Our NECA site safety audits sort of follow a very straightforward process. Working through our specially designed questionnaire worksheet to begin with, our auditors explain daily plans to the guys on site. The inspector crosses the site. We're looking for stuff. If it's a construction site, we're looking at the temporary lighting, backup power, site cleanliness, the site power, tools and ladder condition, temporary distribution board violations and breaches. It basically complies to AS/NZS 3012. And another major component is we carry out an isolation exercise and to see if the guys on site can actually perform an isolation while following the procedures set out in the Safe Work method statement as well. Really cool. We've got a range of experts that can do these site inspections as well, from WHS professionals to ex-Ausgrid inspectors. So depending on the sort of the way you want the inspection to focus on, whether it's more of a quality of the work type scenario or the safety of the work being carried out at the time, you can sort of select the type of expert to come out and do these site inspections. They do cost money, but they're worthwhile having a look into to really double check and make sure your quality processes are in place. Have that second party come in. We can't fine you, we can't stop you from working. All we can do is educate and provide recommendations. So they're very helpful, especially if you're being hassled by unions or by your builders for perceived lack of quality. It's good to get us out there and give you the ticket approval as well. We can currently carry these out in Brisbane, Newcastle, Sydney and Canberra, or anywhere in between. So if that's something that interests you guys, give us a call at NECA and we'll be able to follow that up. We're going to get started shortly, but just a couple more announcements as a few more people come on. Just some upcoming events. 12th of November, we've got the NECA Silica Forum. We're hosting that. It's an in-person event at the Queanbeyan Royal Hotel, just down near Canberra there. We've got Safe Work New South Wales and WorkSafe ACT attending that forum. There has been some legislative changes from Safe Work New South Wales recently in regards to silica, and more recently than the recent ones. We're talking about the registers here. There's been legislation change across both those states now for about the last 2 years. So it's a good opportunity just to refresh yourselves on all the requirements now required in regards to silica management. So wherever you are in the state, consider coming down to that Silica Forum in Queanbeyan at the Royal Hotel on the 12th of November. So you should be able to register for that from our website. As I mentioned before, NECA and MKB, we are going to host a webinar on the 20th of November in regards to mastering those digital tools and understanding and getting the full benefit out of your NECA membership. So if you want to learn more about our AI bot and our MKB, jump onto that webinar 20th November, register for it. It's a good opportunity to understand how those things operate. So yeah. And also we've got our NECA Safety Quarterly Update on the 28th of November. So we've got 4 events this month in New South Wales alone. So we're really pumping out these events. Really good to, the Safety Quarterly Update is a national meeting that we do where we update everyone on all the legislative changes and prosecutions and case law cases that have come through in Western Australia, Queensland, New South Wales, ACT and Tasmania. So you get to see what's happening around the country. And sometimes we do look at Victorian and South Australian cases if they're of interest as well. But we mainly stick to the shared services states that we look after. We used to call it our safety network meeting. We changed names and we've moved platforms to this GoToWebinar platform. We used to have it on Teams. Now I'm in a bit of a panic because only a few people have registered for it. So hopefully everyone jumps on. We normally have about around 30 to 60 people join that meeting. So the quarterly update, and once again, we do them every quarter. Worthwhile coming in and checking that out as well. All right, so we're going to get into the real webinar now. So today's speakers, I'm Owen Leslie too, by the way. I'm the National NECA Safe Manager. I'm hosting today. So thank you and welcome everyone. Our first speaker is Clarence Brown. He's the Director, Policy, Practice and Programs, and also Strategic and Corporate Services for Safe Work New South Wales. Clarence has 10 years of experience in a senior policy roles within New South Wales governments across state and insurance regulatory authority, Environmental Protection Authority, and now Safe Work New South Wales. Prior to his focus on regulatory policy, he's worked as a lawyer in both the private and public sector. So welcome, Clarence. He's going to be our first speaker today. And our second speaker is our very own Neil Roberts, who's our Director of Policy, Technical and Safety at NECA as well. So a bit about Neil. Neil has a long history in electrical work and industries, studied as an electrical fitter mechanic in manufacturing and progressing onto various technical and engineering management roles in the electrical supply industry. With respect to the subject matter today, Neil has accumulated experience in managing electrical trades, personnel, serious incident investigations, and as a state inspector and a subject matter expert for Safe Work New South Wales. expert witness in court, and is currently employed by NECA as the National Technical and Safety Policy advocating for the electrical contractors and the trade in general. And in fact, we've over the last few years, we've really built up our government relations team, and they're doing an excellent job advocating for our NECA members on behalf, of the industry. So if you do have any concerns or issues with any of the regulations, or just want a good whinge, please feel free to call Neil up and sorry about that, Neil, but no, just please feel free to let them know what the issues are, where the hurts are in the industry, and if you think we can do a better job, let us know what we can do. All right, so without further ado, I'm going to hand over to Clarence. Welcome, Clarence, and let you take it from here.
Thanks, Owen, and it's really great to be able to present as part of this webinar today to provide some information about the recent law reforms in the Industrial Relations and Other Legislation Amendment Workplace Protections Act 2025, and particularly focusing on Schedule 3 of that Act, which deals with changes to the Work Health and Safety Act 2011 in New South Wales. So I might just also, before I begin going through the content, I would just like to acknowledge that I'm joining this webinar from the lands of the Camaragal people, and I'd like to extend my respect, or pay my respect to the elders of the Camaragal people, and I'd also like to extend that respect to any First Nations people joining us in this webinar today. So just a bit of a brief timeline around the context for these law changes. So there was a bill that was progressed through Parliament in May and ultimately passed both houses in July. And then the government, the bill itself said that the changes to the work health and safety laws would commence on proclamation, and the government issued that proclamation instrument on the 26th of September, which told us that there would be 3 stages or tranches for these reforms to come into effect. And where we are right now is we're just past that first tranche, which started on the 13th of October. So those set of changes are now in effect and law in New South Wales. And then there will be a second tranche of changes that come into effect from 1 March next year. And then the final change comes into effect from 1 July 2026. So what I'll do now is I'll just go through those changes in each of the tranches and give you the information about what they are and also some insights from my perspective. So the first change is a pretty straightforward one. It's a new definition of registered organisation, and essentially where that term now appears, it means that it will be a union that has to be registered under either the state or the federal industrial relations framework. And the importance of that definition comes up later when we talk about the changes to prosecutions, which I'll touch on later, but just be aware that's a new definition. The next change is a new duty for a person conducting a business or undertaking to notify the regulator whenever they've been issued with a provisional improvement notice by a health and safety representative. So I can say that the Safe Work website has now been updated as of yesterday to enable a portal for PCBUs to go online and provide those notifications. So you can do that via the Safe Work website. And Safe Work will be able to receive those pins and be able to get more of an insight into some of the issues that are arising in workplaces that otherwise the regulator would not have visibility of. But that's a new duty for PCBUs. There's another fairly significant change in the legislation, which is to work health and safety disputes, and it introduces a new Part 5 Division 7A into the WHS Act. and it provides jurisdiction to the Industrial Relations Commission to resolve, hear and determine work health and safety disputes, which is broadly defined, and it essentially covers any matter which you would otherwise, say, request an inspector to be able to assist with resolving an issue in dispute. And I will say on that it doesn't replace that process. That issues resolution process still is in the legislation, but this is a further point at which a WHS dispute or issue could be taken for resolution. And this set of provisions are modelled on the Queensland legislation. So if you went to the Queensland Work Health and Safety Act, you would see largely a mirror set of provisions with some minor changes to account for New South Wales specific jurisdictional elements. I won't go through all the procedure. Mostly the division sets out a lot of the procedure around how the Industrial Relations Commission receives applications. But I thought an interesting point to cover off, sorry, if we could just go back to that previous slide, I've gone a bit too fast. If you look at the that table at the bottom is actually the work health and safety WHS matters that have been heard by the Queensland Industrial Relations Commission. So that's been in place for 7 years, as you can see, and the numbers are quite low. The Queensland IRC produces an annual report which sets out all their disputes, and you'll see that the largest number of their WHS related disputes and matters that they hear really go to entry permit holders and matters around that. And then when you get to these WHS matters, which is now in the New South Wales jurisdiction, the numbers are quite low. So even when we adjust, I guess, for the relative size of New South Wales, Safe Work's anticipation is that that we won't see a lot of WHS matters that go to the IRC based on the Queensland experience, but we'll of course continue to monitor that and see how it develops over time. So we'll go to the next slide, and that does move into changes to rights for entry permit holders in section 118 of the WHS Act. And there's two elements to this. So the changes around, which might be broadly described as ones to do with evidence collection. So an entry permit holder under section 118 of the Act now has new rights to take measurements, conduct tests, or take photos and videos while at the workplace and inquiring into a suspected contravention of the Act, where that is directly relevant to the suspected contravention. So the measurements, the tests that are conducted, the photos and the videos that are taken must be directly relevant to the suspected contravention. And that's an important point to bear in mind when understanding the scope and application of those new rights that entry permit holders have been provided under the Act. And again, that is something that you'll see in several other jurisdictions. They don't appear in the model WHS laws, but several jurisdictions across Australia have included that or a similar variation on that to enable entry permit holder rights for those matters. The other change is on the right, and that goes to a change that was actually made on the floor of Parliament. It wasn't part of the government's original bill. And it provides that no new entry notice is required for a different suspected contravention. So while at the workplace, a WHS entry permit holder who has provided their notice and is inquiring into a suspected contravention of the Act, if they identify another, if they come to reasonably suspect another contravention of the Act while at the workplace, they can inquire into that one without having to provide additional notice. And I would say that Safe Work has been updating its entry permit holders guide, which is available at its website, which will provide a further case study of an example where it's from the ACT, but it is an analogous provision, and where that has been examined by the court and some of the facts around that case. So that should be available, that updated version should be available on the Safe Work New South Wales website very soon. Go to the next slide. And on reviewable decisions, so as you'd be aware, the legislation provides for different parties to be able to seek an internal or an external review of various decisions made by a safe work inspector or the regulator. And what this change does is allow unions now, as one of those persons of standing, to be able to seek an internal or an external review if it is a decision that affects a member of that union. So we'll keep pressing on. So the limitation for prosecutions under the Act has also had a change. So this is to section 232. And it provides now that proceedings for an offence may be brought outside the limitation period if leave of the court is granted. And the condition on that is that the court must be satisfied that the granting of leave is in the interests of justice. So many of you be aware that there is currently a time limitation period of 2 years for to prosecute an offence under the Act after the regulator has essentially become aware of that offence. And now this change provides that a prosecution may be brought outside that limitation period if the court is satisfied that it is in the interests of justice. That phrase isn't defined in the legislation. It is a term that has cropped up in various case law from time to time, but not necessarily in the WHS context. So it will be something where we'll continue to monitor over time to understand how the court will see what is in the interest of justice when a case is brought by a prosecutor to seek to commence proceedings outside the limitation period. And we would anticipate that this would most likely arise in circumstances where you might have a delayed onset between the exposure to the risk and the consequence of that risk emerging. And we see that in a lot of situations such as with dust disease is probably a prime example where that may be the case, and therefore a regulator may seek to commence those proceedings out of time when the consequence of that risk emerges. All right, we'll continue on with the next slide. And that deals with confidentiality of information. So there are several changes here. So there's a change to section 271, which deals with confidential information under the Act and provides that essentially if a person receives documents or information in the course of exercising their powers under the Act, that's to be treated as confidential. And then the section goes on to provide a number of exceptions to that. And there is a new exception now introduced into section 271 subsection 3, which provides that Safe Work may disclose information or notices that have been issued related to its investigations to certain persons who have raised the matter previously with Safe Work. And those persons are actually specified in legislation. It must be an officer of an industrial organisation. It must be an officer of a registered organisation. It must be an officer of an employer organisation or a health and safety representative. And Safe Work has a discretion then to consider the release of that information or document, but it must be satisfied that it doesn't prejudice an ongoing investigation, prosecution, or other exercise of compliance powers. And the other point I'd say about that is, while it is not spelled out in the legislation, Safe Work is providing for, in its internal procedures relating to that matter, an opportunity to notify any third party whose information may be released under that provision, or that Safe Work is considering the release of information on the provision, and provide them an opportunity to provide submissions to Safe Work to help in its, to assist it in its deliberations on that matter. And then the other change to section 271 AA and AB both concern information sharing provisions with information sharing agreements rather with relevant agencies, and it allows Safe Work to enter into information sharing agreements which broadly covers things related to WHS, and relevant agencies are defined under the Act, and they essentially relate to other government agencies either within New South Wales, nationally and even internationally, and they do include law enforcement agencies. We'll move on to the next slide. So they were all the changes that are now in effect as of 13th of October 2025. And now we're just going to turn to the changes that are coming into effect on 1 March next year. So this links back to that definition of registered organisation I talked about earlier. So under section 230, registered organisations with a member concerned in a matter may bring proceedings for an offence under the Act. That is conditional on the registered organisation first consulting with the regulator about their intention to bring the proceedings, and the regulator must also have then declined to bring the proceedings itself. There are also provisions for reciprocal notification for regulators with a registered organisation. And the Act says that where a registered organisation has contacted or Safe Work or the regulator about a matter, and then the regulator does decide to bring proceedings, the regulator is required to notify the registered organisation that those proceedings have been brought. And the other key change here is that a court may now award a portion of any fine following a prosecution to a registered organisation. And now that is currently prohibited under the Act. And from 1 March 2026, that prohibition will be lifted. We'll go to the next slide, which is on WHS civil penalty proceedings. So throughout the Act, there are certain provisions marked as a WHS civil penalty provision, and these provide that proceedings may be brought by the regulator, not as in the criminal jurisdiction, but in the civil jurisdiction for a civil penalty to be imposed. From 1 March next year, registered organisations will be allowed to bring proceedings for WHS civil penalties, and a court may award a portion of any such penalty imposed to the registered organisation. It's important to bear in mind that the conditions on prosecutions relating to consulting the regulator and the regulator having first to have declined to bring the proceedings doesn't apply to these WHS civil penalty proceedings. And just on the right hand side, got some examples. They're not an exhaustive list of the WH civil penalty provisions in the Act, but they are things like denying entry to a permit holder, refusing a permit holder to inspect areas or equipment, or refusing a permit holder to make copies or take photos, etc., in the exercise of their rights under section 118. These are all examples of provisions in the Act that are marked as WHS civil penalty provisions. All right. There is now also or will be a requirement for Safe Work to report on psychosocial matters. And it requires Safe Work to publish a report on its website every 6 months, and also provide a copy of that report to the Minister for Work Health and Safety. And the Act is quite specific that it needs to be split by government and non-government sectors, and it needs to report on the number and types of complaints that Safe Work's received about psychosocial matters, the number of notices it's issued relating to psychosocial matters, and then for Safe Work to provide insights about the issuing of those notices and any recommendations for improving safety and reducing industries. So The first report will be due then after 1 July next year. And I would also mention that this was also a matter that was not part of the government's original bill that was introduced to Parliament, and it was moved as an amendment during the parliamentary process. And then we'll go to the last change that is coming into effect on 1 July next year. Just wait for the slides to catch up. And then this one, there's only one change that comes into from 1 July, and that is a duty to comply with codes of practice. So this will be a new duty under Section 26A of the Work Health and Safety Act. It is a provision that is also found in the Queensland WHS Act. And it's a new duty that requires a person conducting a business or undertaking to comply with a code of practice that's been approved by the Minister for Work Health and Safety. Or alternatively, the PCU must be can do things in a different way to how it's provided for in a code of practice, but it must be a standard of health and safety equivalent to or higher than the standard required by the code. And I've had the opportunity to talk to the Queensland regulator on their experience with this duty, and they provided some useful data about their enforcement activities relating to this new duty. And so for the 7 years or so that this provision has been in place, they've had 0 prosecutions specifically related to this duty and issued 208 improvement notices and just under 50 prohibition notices that have been directly related to this duty. So I think that's quite informative data, and says that over that period of time, that isn't a huge amount of enforcement activity that's directly related to this new duty. And I think one of the reasons for that is that under the existing WHS Act and the model laws, codes of practice can already be used as being as admissible in proceedings for an offence against the Act, and admissible as evidence for things like what should have been known about a hazard, what was reasonably practicable in the circumstances to be managing that risk or hazard. And so in a lot of ways, it's already an important tool for safe work inspectors and the regulator for assessing a PCBU's compliance against the Act, and and to some of those matters that are critical to assessing whether a person is complying with the Act or not. So it perhaps isn't surprising that there hasn't been a huge amount of enforcement activity in Queensland's experience relating to this new duty, because of the way in which codes of practice are already sort of used and applied and considered by the regulator under the existing framework. So probably anticipating a similar kind of experience for New South Wales. Again, we'll continue to monitor that and see how things develop. And then that should bring us to the end of the changes that have been introduced under this new Act. And I think we'll be taking questions after, if there are any, Owen.
Yeah, we'll do the questions at the end. I can't see any coming through at the moment, but I'm pretty sure there will be. So thanks for that, Clarence. What we're going to do, we'll hand over to Neil now, and Neil can go through his presentation, and we'll take the questions at the end. Excellent. Just remember to use the question button at the top right-hand side of the screen as well. No worries, take it away, Neil.
Good morning, everyone. I've got somewhat similar presentation to Clarence, but it's going to be more about what we're concerned about as an industry association and the impacts on your business. So I'm concentrating on those aspects which we think will have an impact, not so much the administrative stuff around what is a registered organisation as such. So can we move the slide, Elizabeth? Okay, so just as Clarence indicated, the bill was introduced in May Schedule 3 of the bill includes all of those changes which Clarence has just run through, some which we consider minor and administrative, several we think are significant for the operation of businesses in this state. I'll make the point here that the changes were introduced with what we believe was completely inadequate consultation with industry associations, and we only physically found out about it in discussions with the acting Deputy Secretary of Safe Work a few days before it passed the upper house. So it really came as a shock to quite a few industry associations. We did attempt to coordinate those industry associations to at least get some discussion happening and review, but that was ultimately unsuccessful and the bill passed. So we'll move on to the next slide. Okay, what does it mean? And I'll qualify this by saying this is the best interpretation and analysis I can provide. And yeah, we'll discuss those concerns later on, but it's an ongoing sort of process. And as Clarence has indicated, I don't think we'll know fully what some of these things mean until we see what activity and actions take place over the coming years. Okay, if we can move on to the next slide. Okay, so from October 13, so I'm going to start going through some of the specific items here. Okay, PCB is required to provide Safe Work with a copy of a provisional improvement notice. So as Clarence said, this is a new duty, and it's similar to the duty to notify of the regulator of notifiable incidents as soon as reasonably practicable. Now this is it indicates a maximum penalty, and I might be wrong in saying that that's a civil offence, because I just checked it. It doesn't say it's a civil offence, but there's the potential there for a PCBU to be fined if they don't provide a notice as soon as reasonably practicable. So there's not massive amounts of PINs issued by HSRs, because unions are pretty active in bringing things to the notice of the regulator. But it's something that our members need to be aware of, is if they do receive a provisional improvement notice from a HSR, they need to log on to that portal and submit it to the regulator as soon as reasonably practicable. So pretty much on the day that they receive it, they should be trying to log on. It's a new provision, and we'll find out if the unions will exercise some activity around that later on. Okay, the next item there, disputes for WHS matters between the parties may be notified by any of the parties to the dispute to the New South Wales Industrial Relations Commission to determine. My read on this one is that, and in the detail, it pretty much indicates that if an inspector has already been appointed to work with a dispute or a WHS matter, at the point where one party refers it to the New South Wales IRC or lodges it in the IRC, the inspector effectively has to cease providing assistance in that matter, and everything gets turned over to the New South Wales Industrial Relations Commission. Now, the Industrial Relations Commission can look at that dispute and determine that they are not going to determine it, in which case it pretty much goes back to the regulator. But there is now that opportunity for a union to raise a dispute if they don't like the way it appears to be going for them, put it into the New South Wales Industrial Relations Commission, for determination. And we basically see that as a somewhat bypassing of due processes that has existed up until now, whereas an inspector from the regulator initially gets involved if any party doesn't like their decision, and if it's a reviewable decision, they can apply for an internal review, and then after the internal review, if it remains in dispute, it goes to the New South Wales Industrial Relations Commission, which is the way it's been managed up until now. So this shortcut process, if you like, is one that's of concern, and we'll basically have to wait and see to what extent unions may attempt to put some disputes into the IRC and try to establish some case law around specific issues. Moving on to the next slide, please. That speaks to my initial point, yep. Okay, as Clarence indicated, extra powers now to gather evidence for a workplace WHS entry permit holder, in addition to making inquiries and obtaining access to documents, copies of documents. Now they'll be able to take measurements, conduct tests, take photos or videos, and may look into other contraventions at the same time if they reasonably suspect there are other contraventions. So this is yes, other jurisdictions already have some of these elements. We raised concerns with the Minister about the use of videos, and I'm really interested in getting some guidance out to our members and taking some advice on how we look at video evidence, and in particular what evidence is permissible once those videos are underway. For example, we don't want effectively interviews being conducted on videos that aren't properly constituted in terms of gathering evidence. So we don't want members to be subjected to effectively questioning from union officials when they aren't being afforded the appropriate warnings that an inspector would give, for example. Okay, next point, Elizabeth. Okay, so this isn't in effect now, but this is an example of basically what comes up on the 1st of March. So the potential maximum penalties for obstructing those above rights, 13,300 for a sole trader, 66,000 for a body corporate BCBU. And as I've indicated, the unions may be able to pursue those in civil proceedings from the 1st of March. So obviously that's of concern. That's a provision we haven't seen before. So, next point. Okay, once again, as indicated by Clarence, the limitation period is now somewhat open, or unions will have the ability to basically apply for leave to prosecute after the 2-year period, or the regulator could as well. General limitation is 2 years, and I'm pretty much aligned with Clarence on this one. It will end up being the subject of case law from the New South Wales Industrial Relations Commissions and the justices there about what fits into that in the interests of justice comment. So next point, Elizabeth. Just move on to the next slide. Yes, and so this is a complementary point, if you like. From 1st of March, a union may commence a prosecution for any offence under the Act after consulting with Safe Work New South Wales and the regulator declining to prosecute. Unions that succeed in a prosecution may be awarded up to half the penalty determined by the court. That's something that's normally been applied to the regulator as the prosecutor, so they generally recover half of the penalty that's awarded. Previously, or currently, so from 1st of March it changes, unions were only able to prosecute Category 1 and 2 offences after following the process, Section 231, which included a request for the regulator to bring a prosecution, and then a process which ultimately would end up in the Department of Public Prosecutions reviewing the case and making a recommendation to the regulator. Now that includes a number of considerations, including consideration of public interest, and unions weren't eligible for payment of penalties. So next slide, please, Elizabeth. And I'll just go back to that previous point, because that speaks to where our concerns are. The risk of prosecutions being used to unfairly target or threaten individuals and businesses for industrial purposes. When we've raised that with the Minister, they've indicated that vexatious prosecutions, there's ability for the court to deal with those or come into a determination on those. Our position is still, though, that that's after it comes to the court. What we don't want to see occurring is threats to individuals or businesses to start a prosecution, which obviously consumes significant amounts of resources and time, without the scrutiny of the court. So it's a genuine concern, and I think as an industry we need to think about how we bring such examples to the notice of the regulator and to the ministers, because there's a lot of things that can happen away from the court which don't appear in statistics, but can nonetheless happen and affect businesses. So next slide, please, Elizabeth. Okay, as Clarence indicated, unions can now initiate civil proceeding for civil actions. We're not going to know how active the unions are going to be. I suspect some will be more active than others, but it's another one of those tools or clubs, if you like, that can be brought to bear against a business who aren't sure of their standing, and obviously it's concerning that unions could effectively independently, without any consultation with the regulator, initiate such procedures. And the fact that they could be effectively compensated for that and this is not up to 50%, they could be awarded the whole penalty by the court. Obviously our concern is that unions may be tempted to weaponise this process and effectively exclude the regulator from management of reasonable WHS disputes. Okay, next slide, please. Okay, 1st of July, codes of practice becoming a duty, or rather the requirement to comply with the code of practice becoming a duty. So that exists for any code of practice that has been gazetted by the minister. And as Clarence indicated, you must either comply with the code or manage the hazards and risks in a way that provides a standard equivalent or higher to the code. And Clarence is quite correct. They are permissible materials in prosecutions, called out explicitly in the Act, but they sit alongside, currently, they sit alongside all manner of other guidance material, including industry guides, Australian standards, and other technical standards that apply to specific material. Even safe work method statements from other parts of industry can be used as guidance material. Safe work alerts can be used as guidance material. So the change here, and where we're quite concerned, we might move on to the next slide, Elizabeth. The codes of practice are imperfect documents, to put it frankly, and the other aspect of that is they quite often refer to other standards and other guidance and external material, which is not under the control of the legislature. So we've got effectively the raising of codes of practice to be a regulatory instrument, and those regulatory instruments effectively falling outside of the control of the Parliament. So it opens up a can of worms, and it's probably a reason why it's only been affected in Queensland previously. The analogy that I have put to the minister and to her office is that we've seen deliberate, if you like, raising of issues under Australian Standard 3012, which is obviously relevant to our industry, for items in that standard, which is a duty under the Act, for items in that standard which are obviously redundant and don't contribute to improved safety on sites. So we've got an imperfect document in which a union is basically saying, sorry, the regulation says you must comply, so we're going to down tools or advise our members to down tools until you comply with our demands on this. Now, I can see that similar sorts of issues are going to come up for items which are raised in the codes of practice. And the fact that it is effectively a duty which is sitting just underneath the primary duty of care, it's a pretty easy step to go, especially for a prosecution at Cat 3, which only requires that a duty is explicit and that someone has failed to meet that duty. There's potentially a prosecution. To have that ability to initiate a prosecution where no one has actually been placed at risk, and really the only offence is this imperfect, not complying with this imperfect document, I think that's an error in regulation effectively. If they can show that someone has been exposed to a risk, then you're potentially bumping it up to category 2. Obviously, my concern is that once again, we see the weaponising of codes of practice to threaten businesses, as opposed to what they have always been, is guidance material to all parties about what is reasonably practicable to manage specific hazards. Moving on to the next slide. Okay. So here I'm basically articulating those concerns. The potential, and I don't know how realistic it is that a union will decide to prosecute Category 3, but if they do, those are the potential fines. Yeah, quite separate from the legal costs that a business may face in defending that action. So I think that's about it. What's the next? Can I get the next slide, Elizabeth? So in summary, from our point of view, the changes that have been discussed are a significant departure from the model legislation, and we have argued that they are contrary to, in some of them are contrary to the objects of the Act itself, and they depart or enable unions to depart from the national compliance and enforcement policy, which at least the regulators observe or try to align their policies with, but the unions are under no obligation to follow that. The unions will have increased ability to assert specific rights at the workplace, initiate criminal civil proceedings against employers, which they have not had before, and bypass the regulator in some cases in taking disputes directly to the industrial court. As I've indicated, the final point there, NECA members who are advised to seek the assistance of NECA WHS for advice on compliance, and NECA Legal for advice if the WHS dispute does end up in the industrial court or other legal action is anticipated. So that pretty much concludes my presentation. I'll hand back to Owen.
No worries. Thank you, Neil. So if anyone does have any questions, put them through on the chat. I can't see any questions. Elizabeth, is that because my view's restricted? Can you see questions coming through? Elizabeth, can't hear you if you are talking.
While we're here, Clarence, have you got any thoughts on my analysis, or you?
Oh, well, no, I mean, I think, I think a lot of these matters are new territory, and it will be a bit of a monitoring exercise to see how it develops. I mean, things are changing for the regulator as well, and it's a new paradigm in some respects for the regulator. So we're very much focused on seeing the implementation is as smooth as possible and working with stakeholders in that. But yeah, I think
you can see where our concerns are coming from, eh?
Yeah, I mean, I understand where the concerns are coming from. I take the points that are made. I guess from the regulator's perspective, obviously we, take an impartial stance as you'd expect, and need to enforce the law as it is. Some of these matters, there's an intersection between the powers and rights unions have been provided under these changes and the regulators' roles, and in other cases there's less of an intersection, and the regulator's not directly involved. So I think where we are involved, we want to do what we can to make sure things operate the way the law is intended, and in other respects, we'll continue to monitor it, and when we have the opportunity, providing advice to government on any insights we have about how the system's operating more broadly. But I think it probably is just a bit too early to take a definitive view on it from the regulator perspective.
And look, there's no criticism towards Safe Work itself. As I've indicated, we've made our representations to the government and in particular the WHS minister, who's also the Minister for Industrial Relations, obviously, about the way these changes were introduced, and basically we consider it a fact. We literally were not consulted, so it's not the regulator's problem. From what I can gather from the regulator, they weren't closely consulted either. But yeah, now we're faced with a situation where quite a few businesses are potentially impacted quite severely if the legislation is misused.
I've got a question. Oh, sorry, Clarence, go ahead.
I'll just say one final point, which is, I guess, in the broader context of the Work Health and Safety Law framework, which I think NECA members would be interested in as well, is Safe Work Australia at that model law level commencing work on a best practice review, which is currently in train, and the genesis of that work is the observation that a number of jurisdictions now have departed from the model laws in material ways, and even within those departures there's differences, and so it's an exercise to try and consult widely, analyze those differences and determine where best practice sits, and for then the model laws to be updated with the aim that jurisdictions then adopt that kind of best practice model. So I think there's a recognition there that, the goal here always should be to have that model law framework and to have that as far as possible consistent through the jurisdictions. And there is a process currently to try and bring that back into a more closely consistent form. That will take some time through next year, but just be aware that that's happening.
No worries. All right, I've got a question relating to your presentation, Clarence, and I suppose I should know the answer to this one. This question is actually from me, but surprisingly, I don't know the answer to this one, so I'm going to ask it. In regards to information sharing arrangements with relevant agencies, how do you determine what is an officer of an employer association or a union? Is there a specific process?
Yeah, that's a good question, Owen. I'll just clarify there. So the information sharing arrangements are a different provision, though that reference to the officer is in that confidentiality provision in section 271. So just making that clear, but there is no definition of officer there for the purposes of that section. So it will be a matter of making sure that our procedures are in place to properly verify the person who's reaching out. I mean, I will say that just generally with that exception now to be able to share confidential information, Safe Work is mindful that that is a potentially, quite sensitive area. There could be implications for personal information as well to be provided. So we're very mindful of the importance of making sure the procedure is very tight around that, making sure we've got that procedural fairness element inbuilt so that any third-party information that may be released, people are aware of that and have an opportunity to have a say on that, like you might see in a GIPA process, maybe not as formal as that, but something akin to that. Short answer to your question, no, there is no clear definition, but Safe Work's very mindful that there needs to be appropriate verification of the authority of those people to request that information.
All right, here's another question on that. Can a relevant agency, an officer of relevant agency, request information after a investigation is concluded in order for education and training purposes?
So again, and sorry, this is probably, I'll say, my presentation maybe wasn't so clear on this. So the relevant agency definition only applies to the information sharing arrangements. So they're basically agreements that Safe Work can enter into with these relevant agencies. So that's a different bucket, and I think your focus here is probably more on those confidentiality provisions. They don't mention relevant agency. They very strictly call out those three entities about officer of an industrial registered organisation, officer of an employer organisation, or a HSR. And there is no limit on the way in which that information, once disclosed, may be used. Right. Okay. So that's why it's important, I think, to get the process right at the front end. Sorry.
That might affect the decision to provide the information, though, if you know that the intent of that information was to be used for education and training to prevent reoccurrence, to maybe prevent a similar fate to another member, so to speak. That might affect your decision to disclose that in the first place, because it may act on what you guys are doing.
Listen, I think that's fair to say. I mean, whenever there's a discretion in the Act, generally that discretion should be applied in a way to support the objects of the Act. That's sort of the guiding, or the guideposts for how these discretions should be exercised. So to the point you're raising, I think, it is a relevant consideration for Safe Work to consider if it's faced with one of those requests for the disclosure of otherwise confidential information.
Yeah. All right. We do have a lot of questions coming through now, so I'm going to get through them. Okay. How does this affect small business? That does not have union in place, and if issued with a PIN, is it mandatory to submit to the regulator? I'm guessing that the PIN wouldn't be issued by a HSR. Maybe it is. Let's assume a small business has a HSR, and that HSR is issued a PIN, but there's no union presence. How does that work with the new regulations, Clarence?
Well, they are, I think Neil was nodding as well. Yep, they are required to, any PIN that's received from a HSR is required to be notified to the regulator as soon as practical.
Yeah, the way I read that section, it's independent of whether there's a union there or not. If HSR issues, the business is obligated to notify.
Yeah. Okay. There's a few questions here. I'm just going to pass through some of the ones for me. I'll get to them. Are PCBUs required to update safety documentation SWIMs to refer to the new Act? They're talking about referencing acts and regulation. Is there a name change to the Act? Mind you, there is no requirement to reference Act and regulation in the work health and safety regulation anyway. It is often requested by PCBUs for reference material to be added on there. So I don't think it's legally, but is there a change? There's no name change to the Act itself, is there?
No, so that Amendment Act, which had a specific name called out, that's just the Amendment Act. Once that takes effect, it basically goes away, but it doesn't change the title of the Work Health and Safety Act.
Yeah. All right, just some comments here. Great discussion from Neil's interpretation. The union has gained sufficient amount of influence and power over businesses from these changes. It would be great to hear from Clarence how these changes are directly linked to improving worker health and safety. So are these changes evidence-based to prevent injury and fatalities on construction sites?
Well, I mean, it's not for the regulator to account for these changes. I mean, what we've tried to do is provide you the information. These are the government's policy decisions, and it's a bill that the government's brought before Parliament, so it's not really for the regulator to comment on that.
That's fair enough. Okay.
I'll comment to say that we haven't been presented with any evidence that these changes will improve safety. I'm quite open to receiving that from the minister or the regulator in due course, but anecdotally, in our industry, Queensland hasn't seen an improvement. They're basically running neck and neck with New South Wales in terms of injuries and fatalities in our industry.
And we seem to get a few mega projects off the line, and Queensland's having trouble building their Olympics. Just as a point there as well.
Yeah. The scary one is, for me, the ability to bypass the regulator and go to prosecutions. That really doesn't exist in any other jurisdiction. So we're a bit of a guinea pig here.
Yeah. Thank you, Clarence and Neil. Great to have NECA advocate for the industry. Can NECA visit our organisation and conduct a review? Okay, I'll get to that in a second. Latitude, common sense. So I'll read this one out. Is there opportunity or latitude, common sense in relation to swims when it comes to working with electricity? It's listed as high risk activity under the Act. Does this mean every single job requires safe work method statements we do as electricians? Doesn't relate to today's. For example, a quick job in a residential house to replace a power point, does this require swims? I'm going to find out who you are, give you a call after this. We'll go over that. Look, quick response. All electrical work is considered high risk electrical work and does require a safe work method statement. Even if it's not high risk construction work, under part 4.7 of the WHS regulation, when you're undertaking electrical work, it still requires a safe work method statement, even if it doesn't meet the definition of construction anyway. So yes, safe work method statements are required under legislation, but there are some simple ways to go about doing it though and solving those problems. So if you're writing a safe work method statement every time you're doing a job, you're not doing it right. And there's risk with doing it that way too. There's a history of fatalities and accidents and injuries that we can put into a safe work method statement that should be in there to protect your workers as well. So we like to use what we call generic safe work method statements specific to tasks that you're doing. But yeah, I can definitely jump onto the phone to you and talk about that further. Copy of the slide. Yeah, go.
Yeah, to add to that, anytime you do an isolation, you're falling into that category of energised electrical work. So you cannot escape the fact that you need a safe work method statement to safely isolate and lock out.
Yeah, it needs yeah, every single job that electricians do, if it's electrical work, that is, anytime you come within 500 mils of an exposed energised conductor, safe work, that triggers the requirement of a safe work method statement, as Neil said. Okay, so just a couple of other things. Yes, today is being recorded and the recording will be loaded up onto our MKB. And yes, a copy of the slides will be added there as well, so that you can further take this and review that. There's other questions here in regards to safety management systems. Does the 165-month safe work method statement pack include the ASP swims? I'll have to verify exactly what product it is, but if you're talking about NECA Safe Generator, yes, they do. And can we come out and conduct a review? Yes, we can, and that's free too, by the way. So the question is, can NECA visit our organisation, conduct a review and provide recommendations on the WHS systems? That's a NECA benefit. So we actually do that for free at no cost. If anyone else is interested in having a NECA Safe advisor come out to your organisation or jump on a Teams call, we're happy to do that. So you just need to let us know where you are. And if you are at the back of Burke or Broken Hill, just give us a few weeks and we'll get there. So it may not be tomorrow, but hopefully you're in a town near one of my advisors. We are spread out across the country and we can get there real quick. Screenshots. I think that's all the questions. I think oh no, there's more. Scopy. After the webinar, will you receive a survey? Oh yes, that's right. I forgot about this. After the webinar, there is a survey. And we're going to welcome all feedback in regards to the platform that we're using, to the information, to what more type of webinars you want to hear as well. So please take your time and fill that out for us so we can bring better, more content that you want to hear as well. And it appears there are no more questions. So once again, Clarence, thank you very much for taking the time out of your day and explaining this to our members. We really welcome Safe Work New South Wales coming to these and taking a few questions as well. Thank you very much for that. And Neil, always a great presentation and point of view. And once again, on behalf of the NECA members, it's great to have the government relations team up and running at full swing now, being able to take our members' concerns to the government. So well done. And thank you very much. We'll leave it there. Thank you.